Hey, welcome back. Let's dig right into lesson number 3, using laws to repair credit. So the fundamental idea of credit repair revolves around your rights as a consumer. The rights you have are all based around a handful of federal and state laws. So what is credit repair? There are a couple different levels of credit repair. There's basic credit repair, and then there's advanced credit repair. Since this is the basic disputing course, we're only going to talk about the basics here. So basic credit repair is a legal way to delete inaccurate, incomplete, and outdated negative credit history by disputing items on your credit. This can be done by disputing items with the credit bureaus or with furnishers that reported the information, like creditors and debt collectors. With the Fair Credit Reporting Act and other laws, you have the right to dispute any information on your credit report. Then, the credit bureaus and furnishers have 30 days to investigate and either verify it is accurate or remove the disputed information. They are also required to mail you the results within 30 days. So when you get the results, you'll know what happened and decide what to do next. Just so we're speaking the same language here, we call these monthly cycles or batches of letters rounds. So the first batch of letters is called round 1, then round 2, round 3, etc. We'll dive a lot deeper into this process later on, but for now, this lesson will give you the basic understanding of the laws and how to use them to your advantage. There are a bunch of different laws, but the most useful piece of legislation for credit repair is called the Federal Fair Credit Reporting Act, also known as the FCRA. This set of laws was enacted to promote accuracy, fairness, and privacy of your personal information relating to your credit. It's the primary set of laws that makes credit repair possible. These laws have really long names, so we like to use acronyms to shorten them up. Again, we're going to call this set of laws the FCRA from now on, okay? Reminder, this is a beginner's course, so without going into too much detail, some of the rights you have under the FCRA are: 1. You have the right to know what's on your credit file. You must be notified if the information in your credit file has been used against you. You have the right to dispute incomplete or inaccurate information, and the credit bureau must correct or delete it within 30 days from the time they receive your dispute. Credit bureaus may not report outdated information. I'm going to discuss this in greater detail coming up very soon. And another rule is your file may only be shared with people or companies with a valid need, usually to consider an application for credit, employment, insurance, or renting. So, you know that all junk mail you get from companies stating that you're pre-approved? They get your information from the credit bureaus. They're called pre-screened credit offers, and you have the right to block those companies from buying that information. Another right that you have under the FCRA is to block your report if you feel you may be a victim of identity theft. You have the right to place a security freeze and stop the bureaus from releasing your personal information. You can also remove the freeze whenever you see fit. If your rights were violated, you can seek damages. By the way, when I say you may seek damages, the FCRA is very specific. Each occurrence can leave the bureau or furnisher financially liable, and you don't need to sue them yourself. Most credit repair companies work with local attorneys that will sue them for you on a contingency basis, meaning you don't pay unless they collect. So that was a summary of the Fair Credit Reporting Act. Seems pretty simple, right? The FCRA is a really powerful tool when used properly. Okay, so here's another long name for you. The Federal Fair Debt Collection Practices Act is the legislation that governs the debt collection industry. For the sake of simplicity, let's call this the FDCPA for short. These laws were enacted to specifically provide limitations on what debt collectors can do when collecting on certain types of debts. The FDCPA prohibits debt collection companies from using abusive, unfair, or deceptive practices to collect debts from you. Debt collectors include debt collection agencies, debt buyers, and lawyers who regularly collect debts as part of their business. There are also companies that buy past due accounts from creditors or other businesses and then try to collect on them. These debt collectors are usually called debt collection agencies, debt collection companies, or debt buyers. The FDCPA restricts debt collectors from calling you before or after certain hours and also does not allow any form of harassment. Additionally, if you have an attorney representing you, the debt collector must contact the attorney instead of you after it's known. Most importantly, as it relates to credit repair, the FDCPA can help you place the burden of proof on the debt collector if you dispute the validity of a debt. Also, the debt collectors must send consumers a letter with some basic information on the debt within 5 days of first contacting them. It must include the amount of debt, original creditor's name, and summary of your rights. If you dispute a debt in writing or demand validation within 30 days of when you receive the required information from the debt collector cannot call or contact you to collect the debt or the disputed part of the debt until the debt collector has provided verification of the debt in writing. This is often very helpful in removing accounts from your credit report that cannot be verified. Here's an example. I once helped a client that had a debt collector trying to collect a really big debt. I think it was over $60,000. The debt collector was calling him at work late at night, really just causing him a lot of problems and unnecessary stress. When I became aware of the issue, I mailed a simple validation demand to the debt collector. In the letter, I simply asked for the written contract for the account they were trying to collect on, and they weren't able to produce it. Then I disputed the account with the credit bureaus, and voila, it was deleted, and the debt collector crawled back under the rock he came from. So, as you can see with the Fair Debt Collection Practices Act, it can be very powerful once you know how to use it. Here's a quick recap. The Fair Debt Collection Practices Act is called the FDCPA for short. It covers when, how, and how often a third-party debt collector can contact a debtor. The FDCPA makes it illegal for debt collectors to use abusive, unfair, or deceptive practices when they collect debts. Basically, no harassment or unfair treatment. If the FDCPA is violated, you can sue the debt collector in a state or federal court for damages plus legal fees. Some attorneys do it on a contingency basis. This lesson is a basic introduction. I highly recommend that you read the full document and learn more with our advanced lessons. I've included a downloadable copy of it for you to read and keep. You should keep them handy while I go through this lesson. The statute of limitation is the length of time an action is valid. There are statute of limitations on all sorts of things. Today, we're talking about credit and debt. So in regards to today's lesson, the statute of limitations is a definitive amount of time that items can appear on your credit report and how long debts can be collected. So there are two different primary statute of limitations here: debt collection and credit reporting. For the sake of simplicity, we're going to call them credit time clock and debt time clock. Again, the credit time clock is the maximum amount of time items can appear on your credit report, and the debt time clock is the maximum amount of time someone can bring legal action on a debt you owe. I created two awesome charts that you can download and keep. They're included in the bonus items on the top of this lesson. Please make sure you download them. They're going to come in handy. We're going to start with the credit time clock first. So, the credit time clock is essentially the statute of limitations for credit reporting. There's a bunch of names for it. It's officially called the running of reporting period. It's also called the statute of limitations for credit reporting, and some people even call it the 7-year rule. I personally call it the credit time clock, and it's one of the most misunderstood parts of the entire Fair Credit Reporting Act. The Fair Credit Reporting Act describes how long items can remain on credit reports and when they must be removed. Some items have a 7-year expiration date, like charge-offs and collections, while other items remain for 10 years, like bankruptcies, some bankruptcies. In the case of tax liens, they can remain indefinitely. So the point I'm trying to make here is that the credit bureaus keep your personal credit history for a specific amount of time based on the item's date of first delinquency. The date of first delinquency is when you stop paying. The following information is taken directly from the Fair Credit Reporting Act and from the Federal Trade Commission's official interpretation of the running of reporting period. Derogatory accounts can stay for 7 years from the date of last delinquency. Inquiries, they can stay for 2 years from the date placed. Some soft inquiries only stay for 6 months. Unpaid tax liens can stay forever. Chapter 7 bankruptcy is 10 years from the date filed. Chapter 13 bankruptcy, which is called a repayment plan, can stay for 7 years from the date the repayment plan ends. This means that if you have a 4-year repayment plan, it could take as long as 11 years to fall off of your credit report. The majority of public records like judgments and child support take 7 years. Closed or inactive accounts generally fall off after 10 years. Positive information can stay forever. One important thing I'd like to mention is that you would expect items to automatically fall off of your credit report when the time clock is up. This, unfortunately, is not always the case. Sometimes errors are made, and often creditors or debt collectors will purposely report false status dates or re-age the accounts in hopes of keeping items on your credit reports longer. The reason they do this is obvious. They want to keep it there longer because the longer something negative is on your credit report, the more likely it is that you will eventually pay it. It's illegal, but more common than you'd think. Alright, let's talk about the debt time clock. So the debt time clock is also called the debt collection statute of limitations. This is the length of time a debt collection agency or debt collector can take legal action to collect a debt. The length of time to bring action is determined by the type of contract, whether it's written, oral, promissory, or open-ended, and it's also determined by the state in which the debtor lived when the debt began. This is a great time for you to pull out that chart that I attached, the statute of limitations on debt collection, which is the debt time clock. So let's discuss the type of debt, and then I'll give you some examples regarding the varying states. First, oral contract. This means that you agree to pay the money loaned to you by someone, but the contract agreement is verbal, meaning you have no written contract. It's basically a handshake agreement. Remember, a verbal contract is legal, but it's tougher to prove in court. Next, a written contract. You agree to pay a loan under the terms written in a document which you and your debtor have signed. Next, promissory note. You agree to pay on a loan via written contract, just like the written contract. The big difference between a promissory note and a regular written contract is that the scheduled payments and interest on the loan is also spelled out in the promissory note. A mortgage is a great example of a promissory note. Next, open-ended accounts. These are revolving lines of credit with varying balances. The best example is a credit card account. It's an account that you can use, pay off, and then use again. Okay, now let's chat a little bit about expired debt. I'd like to talk a little bit more about the debt time clock in relation to when the debt actually expires. It's determined by 2 factors. 1, the type of debt, and 2, the state the debtor lives in. I've attached a copy of the state-by-state chart that outlines the statute of limitations for collection of debt, and it's pretty easy to understand. It would be great if you printed it out and had it handy so you can follow along. I've personally used this chart hundreds, if not thousands of times to help my clients. Knowing if a debt is expired or not gives you a real edge. The chart you see on my screen is a screenshot of the chart I attached to this lesson. Once you understand it, it's pretty awesome to be able to answer questions for any situation. For example, let's say that you stop paying a credit card debt in the state of Florida and it was sold to ABC Collections. And ABC Collections is coming after you. They're calling you, sending you letters, or threatening to sue you. They want the money and they want it now. The statute of limitations on debt collection protects you. In this example, if it's a credit card, that would mean it's an open-ended account. We went over this a few minutes ago. Revolving accounts that you can use, pay back, and then reuse means open-ended. You would simply scroll down to Florida, then go to open-ended column, and it says 4 years. So with that being said, the length of time the creditor has to collect the debt is 4 years from the date of last activity. Now, the date of last activity is when you last made a payment. If you never made any payments, it would be the date you opened the account. So in this example, if your last payment was over 4 years ago, technically you no longer owe this debt and it's no longer valid. Let's do another example. Let's say that you live in Louisiana you had a personal loan and you stopped paying it. That would be considered a written contract. Once you've signed the written contract, you're bound by the terms of the contract. If you default on the terms of the contract by failing to make payments as agreed, the other party may take certain actions to pursue you for what you owe. One of those actions would include filing a lawsuit against you to get you to get up and pay. If they decide to sue you, they would have 10 years before that debt would be expired. Okay? I would also like to point out that they would also be able to sue you after the 10-year expiration date. But if you can prove that the debt is expired, it's highly unlikely that they would win. Knowing when debts expire is extremely helpful for so many reasons. One, creditors and debt collectors know that most consumers don't understand how long debts are valid, and being able to stand up for your rights or help clients do the same is very powerful. And two, knowing when debts expire gives you a big advantage if you're ever sued. And three, it gives you leverage. I would highly recommend you print out and keep copies of the charts I attached. They will definitely come in handy. Just like the last lesson, please take a minute to read the text on this page, and I'll be waiting for you in the next lesson after your quiz.